What will happen to Donald Trump if the Supreme Court rejects his Alien Enemies Act claim? What happens when a president tries to twist a centuries-old wartime law into his personal shield and the nation's highest court is ready to call his bluff? Donald Trump has staked a dramatic part of his defense on the Alien Enemies Act, a statute from 1798 meant to deal with foreign adversaries in times of declared war. He claims it gives him sweeping powers to justify actions that critics call reckless, unlawful, and dangerously authoritarian. But here's the catch. If the Supreme Court rejects his argument, Trump could face not just a devastating legal blow, but also a political earthquake that shakes his 2024 strategy to its core. His enemies see this as the ultimate check on his power grab, while his allies warn of chaos if the court rules against him. The stakes are nothing less than Trump's future and America's constitutional balance. Stay tuned as we break it down right now. The dispute surrounding Donald Trump's attempt to use the Alien Enemies Act to justify mass deportations of Venezuelan nationals may seem, at first glance, like a technical legal battle. But when one examines the larger context, it becomes clear that this controversy is not a narrow dispute over a centuries-old statute. It is, in fact, a defining moment for the American constitutional order. The Supreme Court's decision will answer a question as old as the Republic. Does the president have the unilateral authority to decide when the nation is at war? And if so, can he suspend the rights of individuals in the name of national security? Trump has long built his political brand on presenting himself as a strongman willing to take extraordinary measures against perceived enemies, foreign and domestic. The Alien Enemies Act provided him with a convenient vehicle, a rarely used law with roots in the late 18th century that could be reinterpreted to fit a 21st century political narrative. Yet the Fifth Circuit Court of Appeals rejected his attempt, finding that the factual predicate required for the act, a declared war or a predatory foreign incursion, simply does not exist with respect to Venezuela. The Supreme Court now holds the final say. If the justices reject Trump's claim, the immediate effect will be to curtail his deportation program. But the deeper consequence will be to reaffirm that even presidents who cultivate an aura of strength are still bound by law. If, however, the court were to accept his claim, it would signal a seismic shift in the balance of power between Congress, the courts, and the executive. This introduction underscores why the question posed, what will happen to Donald Trump if the Supreme Court rejects his Alien Enemies Act claim, is both legally intricate and politically explosive. To understand the gravity of Trump's actions, one must revisit the origins of the Alien Enemies Act. Passed in 1798 alongside the Alien Friends Act, the Sedition Act, and the Naturalization Act, the Alien Enemies Act was part of a package designed to strengthen federal authority during a period of tension with France. It specifically authorized the president to detain or deport nationals of a hostile foreign power during times of declared war. While most of the other laws expired or were repealed, the Alien Enemies Act remained on the books. Its historical use has been rare but consequential. During the War of 1812, the government relied on it to justify the detention of British nationals. In World War I and World War II, presidents invoked it to detain and, in some cases, deport individuals from enemy nations. Most notoriously, Franklin D. Roosevelt's administration used it in tandem with executive orders to justify the internment of Japanese and German nationals, an episode now recognized as a dark stain on American civil liberties. Importantly, each of these instances occurred during a formally declared war. Congress had authorized hostilities, and the presence of enemy nationals on American soil was viewed, however harshly, through the prism of wartime necessity. Trump's attempt to apply the statute in the absence of a declared war is unprecedented in modern American history. By framing Venezuela as an enemy without congressional approval, he sought to stretch the act far beyond its original intent. That historical context is central. If the court rejects his claim, it will be reaffirming that the statute cannot be divorced from the condition of war for which it was written. If it were otherwise, the act would become a blank check for executive overreach. The Trump administration's legal argument rests on the notion of executive deference. His lawyers contend that when the president declares that the nation faces a predatory incursion, the judiciary must defer. They argue that foreign policy and national security are the exclusive domains of the executive, and that courts lack the institutional competence to second-guess such determinations. Judge Andrew Oldham, in his dissent at the Fifth Circuit, echoed this view, suggesting that if a president declares that a foreign power has launched an incursion, courts must accept that declaration as fact. But this argument is inseparable from its political context. Trump's motives are transparent. He sought to manufacture the perception of war in order to consolidate domestic power. The dramatic incident of the boat explosion in the Caribbean was presented as evidence of hostilities, yet it conveniently coincided with the release of the Fifth Circuit's adverse ruling. By amplifying the narrative of conflict, Trump attempted to justify extraordinary measures at home. Politically, it allowed him to portray himself as a defender of American sovereignty under attack, rallying his base around themes of nationalism and toughness. Legally, it offered a way to bypass the slower, rights-protective procedures of ordinary immigration law. If the Supreme Court rejects his claim, it will not only dismantle his legal strategy, but also expose the political theater behind it. His argument for executive deference would collapse, and the ruling would send a clear signal that courts will not rubber-stamp manufactured crises. The Fifth Circuit's decision provides a fascinating glimpse into the judiciary's struggle to navigate Trump's claims. The majority opinion, authored by Judge Southwick and joined by Judge Ramirez, was unequivocal on the central issue. There is no war, no invasion, and no predatory incursion by Venezuela. Without those conditions, the Alien Enemies Act does not apply. The majority underscored that while the government retains other statutory tools to deport individuals, it cannot shortcut due process under the guise of wartime necessity. The ruling also addressed the due process question, with a split over whether 7 days of notice for deportees was sufficient. Judge Southwick and Judge Oldham concluded it was, while Judge Ramirez argued for a longer notice period. This secondary dispute highlights the tension between efficiency and fairness, but it does not alter the central holding that Trump misused the act. The implications of this ruling are significant. First, it demonstrates that even conservative judges are unwilling to grant unchecked authority to the executive in the absence of factual grounding. Second, it frames the issue in a way that almost compels Supreme Court review. By acknowledging the lack of clear precedent and expressing judicial humility, the Fifth Circuit effectively invited the justices to provide definitive guidance. Finally, the ruling signals that lower courts remain wary of Trump's expansive claims, suggesting that his legal strategy is increasingly isolated. If the Supreme Court affirms, it will validate the cautious approach of the Fifth Circuit and reinforce judicial independence. At the heart of this case are two foundational constitutional principles: the separation of powers and the guarantee of due process. Article 1 of the Constitution grants Congress, not the President, the power to declare war. By attempting to treat Venezuela as if a state of war existed, Trump encroached on legislative authority. Accepting his claim would effectively transfer the war-making power to the executive branch, a move the framers explicitly sought to prevent. The Fifth Amendment further complicates his position. It guarantees that no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court has repeatedly held that this protection extends to all persons within U.S. jurisdiction, including non-citizens. Trump's attempt to use the Alien Enemies Act to deport individuals without individualized hearings runs directly contrary to that principle. His administration framed deportations as a matter of national security urgency, but urgency does not erase constitutional rights. If the Supreme Court rejects his claim, it will reaffirm these principles, underscoring that neither fear nor political expediency can suspend constitutional safeguards. If it accepts, however, it will erode both congressional authority and individual rights, marking a dangerous precedent for future presidents. The personal and political consequences for Trump if the court rules against him would be multifaceted. Legally, his deportation initiative under the Alien Enemies Act would collapse. thousands of Venezuelans targeted for removal would be entitled to due process hearings, overwhelming immigration courts, and undermining his promise of swift action. The administration would be forced to fall back on slower, more procedurally demanding statutes. Politically, a rejection would expose Trump's overreach and undercut his image as a leader who gets results. His critics would seize on the ruling as evidence of authoritarian tendencies, while his supporters might feel frustration at yet another legal defeat. It would add to a pattern of judicial setbacks, from the rejection of his travel bans in earlier years to limitations on his efforts to rescind protections for undocumented immigrants. Internationally, a rejection would demonstrate to allies and adversaries alike that American courts remain independent and capable of checking executive excess. This could reassure nations concerned about Trump's unpredictability. Domestically, it could embolden Congress to reassert its authority over war powers, potentially leading to legislation clarifying the limits of the Alien Enemies Act. For Trump personally, the defeat would reinforce a narrative of failure in the courts, diminishing his ability to project strength in future political battles. While Trump faces serious consequences if his claim is rejected, the dangers of the court accepting it are even more profound for the nation. If the justices endorse his interpretation, the Alien Enemies Act would become a tool for executive manipulation. Any president could declare a foreign adversary to be engaged in a predatory incursion and use that declaration to detain or deport nationals en masse. The requirement of congressional declarations of war would be rendered meaningless. Civil liberties would face immediate peril. Individuals could be deprived of liberty or expelled from the country without meaningful hearings, based solely on the president's word. This would create a precedent for suspending constitutional rights whenever the executive perceives a threat, real or imagined. The slippery slope could extend beyond immigration. A president might justify domestic crackdowns, surveillance programs, or even martial law by invoking phantom incursions. For Trump, a favorable ruling would be a political windfall. He would portray it as proof that the Supreme Court validates his strong leadership and his ability to bypass bureaucracy. But the long-term cost to American democracy would be severe. The framers designed checks and balances to prevent precisely this concentration of power. Accepting Trump's claim would erode those safeguards, leaving the nation vulnerable to authoritarian tendencies from any future president. The outcome will depend heavily on the ideological composition of the court and the judicial philosophies of its members. Justices Alito and Thomas have historically favored deference to the executive in matters of national security. Justice Gorsuch, though conservative, has sometimes shown libertarian skepticism of unchecked government power. Chief Justice Roberts has demonstrated an interest in preserving institutional legitimacy, occasionally siding with liberal justices to avoid radical outcomes. The liberal justices, Sotomayor, Kagan, and Jackson, are likely to view Trump's claim with deep skepticism, emphasizing constitutional rights and the dangers of executive overreach. The pivotal votes may come from Roberts, Kavanaugh, and Barrett, who must balance conservative leanings with institutional concerns. Their decision will not only resolve the case at hand, but also shape the legacy of the court in an era of intense political division. The justices must decide whether to treat this as a narrow statutory interpretation, simply ruling that the Alien Enemies Act does not apply without war, or as a broader constitutional pronouncement on executive power. A narrow ruling could leave questions unresolved, while a sweeping rejection could decisively limit future presidents. The court's divisions reflect the nation's broader struggle with the boundaries of authority in an age of polarized politics. The Supreme Court's ruling will reverberate far beyond the courtroom. If the court rejects Trump's claim, it will reaffirm the resilience of constitutional democracy. It will signal that even in moments of political theater, the rule of law remains paramount. This could strengthen public confidence in judicial independence at a time when many fear institutional erosion. It could also embolden Congress to reclaim its war powers, reasserting the balance intended by the framers. If the court accepts the claim, however, the implications are dire. It would normalize executive overreach, creating a precedent for unilateral declarations of warlike conditions. It would weaken Congress, marginalize the judiciary, and erode civil liberties. Future presidents, Democrat or Republican, would inherit this expanded authority, and the temptation to use it for political gain would be immense. The line between genuine national security threats and manufactured crises would blur. For Trump, the stakes are immediate. A rejection would expose him as a leader constrained by law, while an acceptance would empower him to pursue his agenda with fewer obstacles. For the nation, the stakes are existential, whether democracy endures as a system of checks and balances or slides toward concentrated executive dominance. The case now moves into the hands of the Supreme Court, where oral arguments and written briefs will determine the contours of executive power in the 21st century. The decision will likely arrive in the coming term, shaping not only Trump's presidency but also the constitutional landscape for decades to come. If the court rejects his claim, Trump will suffer a significant political and legal defeat. His deportation program will collapse, his narrative of strength will falter, and his opponents will gain ammunition to argue that he consistently overreaches. It will reaffirm that the Constitution still constrains even the most aggressive leaders. If the court accepts his claim, however, the consequences will be far more dramatic. Trump will be emboldened, civil liberties will be weakened, and the delicate balance of power will tilt decisively toward the presidency. So what will happen to Donald Trump if the Supreme Court rejects his Alien Enemies Act claim? He will face legal defeat, political humiliation, and the sobering reality that even in an era of populist strongmen, the Constitution still speaks with authority. For the American people, such a ruling would be more than a rebuke of one man. It would be a reaffirmation that in a republic governed by laws, no individual, not even the president, stands above the Constitution.